Good afternoon. Thank you. We'd just like to welcome everyone here to the 37th Annual Robert F. Wagner Labor and Employment Law Moot Court Competition, the final round. It's been an exciting competition so far. We are very much looking forward to this final round. At this point, we would just like to thank again the fact pattern authors, William Kleindienst, Caitlin Tooker, for their very hard work in creating such a wonderful fact pattern, the faculty advisor on the pattern, Professor Peggy Leibowitz, and the Moot Court faculty advisor, Professor Susan Abraham. So thank you, guys.
Okay, so just before we begin, we're just going to have a few other announcements. So make sure, your cell phones are off. Obviously, we all know this. So thank you all for coming as well. And if you could the way it's going to work, we'll have our final round panel. It's going to be Jacqueline Berrien, the chair of the EEOC, our new dean, Dean Crowell, Judge Irenas from the New Jersey Federal District, and Ron Meisberg, who is the ex-general counsel of the NLRB and currently is a partner at Proskauer Rose, and Ann Staveson, who is the chairperson for the New York Industrial Board of Appeals. So it should be a very exciting bench, and the way it's going to work, we'll have them come out and then have the arguments, and then they will leave to go deliberate in their judge's room. So if you could all stay while the judges are deliberating and then wait for their final decision once they come back and finish deliberating, we'd really appreciate it. So that's it, and we're going to get started shortly. So thank you all for coming again, and we look forward to the round. And thanks.
So basically, we started straight up just Been doing this for 40 years, I know.
For like 10 minutes.
I just wanted to get it like this.
Yeah, no, we got that now.
We're going to be starting the competition now, or the final round, rather. So we're going to bring the judges in. Thank you.
business before this, the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Berry, Crowell, Meisberg, Stevenson, and Chief Justice Irenas presiding.
Everyone, please be seated.
The first case on the calendar, this 24th day of the month of March 2013, is Ernie Hudson et al. As petitioners against Grover Waste Solutions Incorporated. As respondent.
Excuse me, before we begin the argument today, I'd just like to introduce my fellow justices, all of whom were very recently appointed to the Supreme Court of the United States. But prior to their recent appointment, Jacqueline Berrien, to my immediate right, is the chairperson of the United States Equal Employment Opportunity Commission. To my far left, if you don't recognize him, you're all in big trouble. It's Dean Anthony Crowell, our esteemed Dean of New York Law School. Ronald Meisberg, to my far right, is the former General Counsel of the National Labor Relations Board and presently a partner at Proskauer Rose, an esteemed law firm throughout the country. And finally, to my immediate left, Ann Stevenson, who is chairperson of the New York State Industrial Board of Appeals. And I'd like to welcome all of them as new members of the Supreme Court. I, for 21 years, have labored as a judge of the United States District Court in New Jersey, and of course very pleased to be elevated to the Supreme Court for this argument. Okay, we'll call our first case, which is Henson versus Grover.
Good afternoon, Mr. Chief Justice, Associate Justices, and may it please the Court. My name is Catherine Fraser, and Catherine Fraser, F-R-A-S-E-R. And I, along with my co-counsel, Mr. Zachary Webster, represent the petitioners in this matter, Mr. Ernie Henson and those similarly situated at Grover Waste Solutions. We would like to request 2 minutes for rebuttal.
Fine, you have it.
Your Honors, there are 2 issues before the Court today. I will address the first issue regarding the compensability of time under the Fair Labor Standards Act, and my co-counsel will address the unlawful terminations under the National Labor Relations Act. Your Honors, the intent, the purpose behind the Fair Labor Standards Act is to ensure that all employees get paid for all of the time that they work, including Mr. Henson and waste treatment specialists at Grover. The time that they spend donning and doffing personal protective equipment, traveling to and from the shower room, and showering at the end of their shifts is compensable for 3 reasons. First,
how long does it take?
Your Honor, the District Court found that the total amount of time that waste treatment specialists spend each day is 30 minutes. And that's stated in the record at page 5.
Which is what, sorry?
30 minutes, Your Honor.
That for both ends, both before donning and doffing?
The record indicates that the walking time takes 5 minutes on each side of the day, and the rest of the 20 minutes is spent in donning and doffing the personal protective equipment and showering. These activities, as to my first point, these activities are integral and indispensable to the principal activity of treating waste. As President Roosevelt said in urging Congress to pass the Fair Labor Standards Act, employees deserve a fair day's pay for a fair day's work.
But isn't there a special exception for this type of activity after the Portal to Portal Act? Wasn't there 2030?
Yes, Your Honor.
And doesn't it specifically say that customer practice will take this kind of activity out of the range of hours of work?
Your Honor, Section 2030 was enacted in 1949, 2 years after the Portal to Portal Act. And Section 2030 does provide an exemption for clothes changing and washing time in the collective bargaining context where there is a legally valid custom or practice, which excludes that time. Now, this court in Detroit and Toledo Railroad found that for a legally valid custom or practice to exist, 3 elements are required. First, time. Second, knowledge. And third, acquiescence. The record clearly states that the first 2 elements have been met here. However, there's not sufficient evidence of acquiescence.
What about the provision in the collective bargaining agreement where employees are paid for lunchtime? That's 30 minutes too. And that under the Act, they don't have to be paid for lunch.
Yes, Your Honor. However, the Fair Labor Standards Act and Portal to Portal says that principal activities must be compensated for. And there's no explicit provision in the CBA that says that that paid half an hour lunch is taking the place for this half an hour of time that they spend each day.
Well, if we accept your argument, don't we have to now start to pay people for the time it takes them to walk to the cafeteria or the break room?
No, Your Honor. As the court found in IPB versus Alvarez, under the continuous workday rule, once the first principal activity starts and until the last principal activity takes place, that time is compensable. So when it is after the first principal activity, then that time walking between activities at work is compensable.
Suppose they changed into this clothing at home. Would that make all the time between the time they got up and changed into these clothes through the end of their workday compensable?
Not necessarily, Your Honors. However,
Why would it or would it not, do you think?
in this case, if the personal protective equipment were able to be donned and doffed at home, then no, it would still remain compensable time here, because these activities, to be necessary, the courts usually look at whether the activity is required by law and by the employer. And here, this activity is mandatory safety protocol for Grover. Additionally, this activity is mandated. Wagner state law provides that these personal protective equipment must be provided to employees who work with dangerous chemicals. And OSHA provides that these personal protective equipment must be used.
But you're saying if they donned this at home, that would not be compensable time?
Your Honor, we contend today that because it is for safety purposes and it is at the facility, that it is compensable. If it was donned and doffed at home, perhaps it would not be compensable. It might take less time. However, Grover does require that these personal protective equipment stored at the facility, that they have to change into it at the facility, and that they have to shower before the end of the shifts. Now, as this court found in Steiner, where the employees were in a battery plant and had to deal with lead and other dangerous chemicals, they had to shower at the facility to ensure that that safety and public health risk didn't come into their homes. So petitioners would contend today, Your Honor, that these have to be done at the facility. And because they have to be done at the facility and because they are required by law, that these are principal activities which deserve compensation. And this is in line with this court's holding in the Steiner case, and also implicit in the holding of IPV versus Alvarez, that donning and doffing personal protective equipment at an employer's facilities is compensable time.
Well, say that 2030 applies. Why are we going to another analysis as to whether it's a principal activity?
Your Honor, in order for time to be compensable, it must first be found to be a principal activity. Then the court will turn to the consideration of whether it is under the exemption in Section 2030. We contend today that this is a principal activity and that it is not covered by Section 2030 because there was no legally valid acquiescence. Now, as the court found in Sepulveda, where employers and the union engaged in active negotiations, and that evidence was shown by the employer, then in that situation, the subsequent silence in the collective bargaining agreement is valid acquiescence. We request a ruling from the court today that silence is not going to be enough to allow for a custom or practice to be inferred. And this is in line with this court's holding in Detroit and Toledo Railroad, and also with congressional intent in passing Section 2030. Representative Christian Herter, in passing Section 2030 specifically, stated that the intent of this provision was to ensure that employers and the union carefully threshed out issues of compensation. Yes, Your Honor.
Can we infer anything from the fact that these employees didn't go through their union representative to seek compensation for this period of time. They went directly on their own. Can we infer from that that the union took the position that it wasn't compensable?
No, Your Honor. As the record states at page 5 and page 6, the petitioners in this case considered bringing this to the union first, but then determined to try and resolve the issue with their supervisor. However, when they tried to resolve the issue with their supervisor, they were fired. So they never had time to bring it to the union, Your Honor.
What do you make of the CBA clause that says no local working condition shall be established except as it is expressed in writing in an agreement approved by the facility manager and the local union president? There was no such written agreement here concerning non-compensation, was there?
Exactly, Your Honor. Since there was no written provision, the local working conditions excludes this from compensable time. And this clause in the collective bargaining agreement speaks more fully to the party's intent than silence ever could on this issue. And the specific statement, the shall be language in the local working conditions provision, does not make that section only prospective. It also makes it retroactive and is more in line with actions that shall be brought up under this policy. So the petitioners do contend that the local working conditions provision prevents unwritten customs or practices regarding wages and hours worked.
Isn't there more here, though, than just silence in the CBA? Aren't there many years of practice, and there have been several renegotiations of the CBA? So certainly if this was a concern of the union, they would have expressed it in any number of occasions.
Your Honor, silence, no matter how long of a period of time it takes place over, will not be enough to infer acquiescence under this rule. And as I stated previously, that is in line with congressional intent and with several district courts. As one district court stated, an employer should not be able to ignore or evade the requirements of the Fair Labor Standards Act simply by showing a history of ignoring them. The intent of the Fair Labor Standards Act itself is to prevent exploitation of workers and ensure that they get a fair bargaining with their employer. And here, that intent would call for a ruling that there was no valid customer practice here.
Grover argues that the time involved is de minimis. Do you think de minimis should be measured by 1 day's time, a week's time, a month's time, a year's time? What period of time do I look at, from a counterpoint of view, in determining whether a particular time is de minimis or not?
Your Honor, the court found in Lindau that you consider three factors. The court found in Lindau that you consider three factors to determine whether time is de minimis: how regular the time is, how easy it is to track, and the significance of the amount of time. Under these rules, for regularity, you would look at this on a day-to-day basis. And employees, waste treatment specialists...
One day and say, is that time de minimis? Or do I look for a week's time, a year's time, a month's time?
You look at the fact that the employees engage in this activity every day, and that aggregately, this amounts to $2,600 a year that they're not being compensated for. And this is a significant amount of time. And all three of the factors of the Lindau test are met here because it does happen every day and it is easy for the employer to track. And as the district court found, who is the fact finder, that it does take the employees 30 minutes every day.
But that includes some socializing, does it not?
Your Honor, there's some evidence that the employees socialize as they're walking to the locker rooms. However, there's no rule that employees can't chat while they're completing work activities. And additionally, the employer has put forth no evidence of how much time is spent in these activities or socializing. The fact is that walking takes 5 minutes and 10 minutes total, and 30 minutes throughout the day are spent in activities which are mandated by Grover that they're not being paid for. As to, yes, Your Honor.
Is the protective equipment closed? Are they in fact closed?
No, Your Honor. And that is also under Section 2030. Petitioners argue that the personal protective equipment at issue here, which is special and unique, required for safety, required by the employer, and required by law, do not fit within the ordinary plain meaning of clothes as we understand them today.
But Judge Posner in the Sanderford case said that if this was changing clothes into it all operates to be changing clothes, since it's never you're likely to be changing street clothes into other street clothes. Isn't the notion of this being something different than your street clothes inherent in the exclusion for these kinds of activities?
Your Honor, certainly Congress meant in passing this statute when they said clothes to mean clothes that are appropriate for the workplace. However, Section 2030 was enacted in response to a case regarding baker's clothing. And that clothing at issue was an apron and a pair of gloves, which does not at all resemble the kind of extensive personal protective equipment at issue today. In the case of Alvarez, the Ninth Circuit found that that clothing can cost up to $600. And where that clothing is required for safety reasons and required to be donned and doffed at the employer facility, it should not be within the meaning of clothes under Section 2030. Therefore, that time cannot be bargained away. Thank you for your time, Your Honors.
Good afternoon, Mr. Chief Justice, Your Honors. May it please this Court, my name is Zachary Webster, co-counsel for petitioners. Grover Waste Solutions has crafted an overbroad and confusing social media policy and then fired 3 of its employees for allegedly violating it, instilling fear on behalf of its entire employee base and preventing them from using the online community as a source for workplace grievances. We urge this Court to find that the district court's holdings are in fact fair, that these are unfair labor practices. There are 3 issues on review. The first is that in crafting the social media policy, Grover created a vague and ambiguous policy that is unclear as to what type of conduct is prohibited. It is thus unlawfully overbroad. Second, through enforcement by firing 3 of its employees, Grover infringed on the protected concerted activity.
Counsel, let's assume the 3 employees got together and they were very unhappy and they were protesting working conditions. But they did it in a way which was massively offensive, obnoxious, hurtful. Could they forfeit their Section 7 rights? Notwithstanding that the object was legitimate, but by expressing their rights or their alleged rights in an offensive, terrible way, could justify forfeiting those Section 7 rights. Is that possible?
It is absolutely possible. Certainly, Your Honors, even when engaging in protected concerted activity, if such conduct was so opprobrious or disloyal or insubordinate, those particular actions would forfeit protection of the National Labor Relations Act. But the fact remains that that has not occurred here. The petitioner's conduct was not near so egregious to forfeit the protection of the Act.
Do you maintain that the entire rule is unlawful or just a part of it?
At least several portions of this particular...
What portions?
In the social media policy, for example, Grover dictates to its employees that they must avoid any conduct that adversely affects their suppliers, their clients, and their legitimate business interests without providing any limiting language or anything that might clarify what these things might mean. And in that, employees will read this and be unclear whether the actions that they might take by posting online would include actions about protesting their working conditions. That ambiguity...
Disclaimer in the policy, right? It says, nothing here shall be seen as violating the National Labor Relations Act. Isn't that sufficient?
It's not sufficient, Your Honor. As the Board has held in several cases, including McDonnell Douglas and an Ingram book, the disclaimer itself, if it is attenuated from the rest of the policy and the substance itself is unclear, will not save a policy such as this. So in this case, the disclaimer put at the very end, without tying back in any way to the various provisions, still leaves some confusion as to what the provisions might mean.
You know, when we certified this question, we said, does an employee commit an unfair labor practice under the NLRA by promulgating a social media policy that bars employees from posting statements online, quote, that reasonably could be viewed as malicious, obscene, threatening, humiliating, offensive, or intimidating, close quote, and then goes on. Is there anything about the part that we certified and quoted that you find to be an unfair labor practice?
Absolutely, Your Honor. Within that litany of words, at least the term offensive has some ambiguity as to its meaning. And Grover cannot bookend an unlawful provision with some that are lawful. The word malicious or abusive, these types of adjectives can accompany prohibitions and be lawful. But as the Fourth Circuit held in Beverage Air Code, the mere presence of some overbroad rules will still tend to chill the exercise of an employee's Section 7 rights. So even within the certified language, Your Honor, the word offensive alone, as bookended by other words that might be clear to the employee, will leave some uncertainty as to what's going on.
Well, what's the standard here? I mean, we have this list of things that an employer says we don't want you to post on social media malicious, obscene, threatening, humiliating, offensive, or intimidating comments. What is the standard by which it's judged to be one of those things?
The standard is an objective one, Your Honor. As this Court has held, as the Board and nearly every circuit has affirmed, it's an objective test.
An objective from whose viewpoint?
If a reasonable employee reads the policy and it tends to interfere with, coerce, or restrain the exercise of her Section 7 rights, her right to engage in concerted activity or collectively bargain, then it is unlawful as overbroad. It covers too many possibilities.
Is it possible to draft a code of conduct that doesn't have some ambiguity in it? Is it humanely possible to do that?
It absolutely is, Your Honor. If Grover states legitimate business interests and then goes on to define what these interests are with clear limiting language, and those particular prohibitions and provisions serve those purposes, then it can be lawful. It can be made clear to employees. That's why an injunction needs to be placed on this policy, because it is not clear to employees.
Well, if we agree with you, which part of that policy should we say has to be retracted, or is it all of it?
There are several provisions. What I have already mentioned, the fact that anything that adversely affects Grover's clients, its suppliers, its employees, or its legitimate business interests by itself is vague. Secondly,
are you asking us to throw out the whole policy?
No, not at all, Your Honor.
Which parts of it do you want us to throw out?
Nothing needs to be thrown out per se. What needs to happen is to include limiting language that gives context and meaning to the various prohibitions on conduct. For example, Your Honor brought up the disclaimer. If the disclaimer was brought to the top of the policy, for example, and reads, Grover wants to protect all of its employees from harassment in the workplace. In these endeavors, we would like to do A, B, and C. However, we want you to know as employees that nothing in this section is intended to interfere with your rights. If the disclaimer was...
Doesn't it already say that?
It says that.
That was the point that Justice made before, that there is a disclaimer.
There is.
Policy. Why doesn't that do the job?
Why is that insufficient?
This is all one part of several pieces. It's just one example of how to help clarify this policy. Move it to the front and indicate that everything, including these particular examples, what it means when it says it's not intending to interfere. The particular heading that reads, post only respectful and appropriate conduct, has no provision under it that says anything about what appropriate or respectful conduct might be. This is distinguishable from a particularly relevant...
Respectful, a very vague word. I mean, that seems to be a lot vaguer than these words. Respectful conduct?
Absolutely, Your Honor. That's precisely the point. Respectful conduct could mean a variety of things that we each may interpret differently. Costco wholesale...
An employer that you're not paying me for legitimate work I'm doing doesn't sound respectful to me.
How do you distinguish this from Costco?
In Costco, the court found that a particular provision that read, post or use conduct that's only appropriate business decorum clearly was intended for its employees to further a civic work environment. That type of limiting language is not applied here. We only have the word appropriate or the word respectable standing on its own as an adjective without...
They're largely synonymous.
Pardon, Your Honor?
Why can't you view them as largely synonymous?
I'm sorry, could you rephrase that?
Why can't you view the two policies as largely synonymous, respectful, appropriate?
Because it doesn't refer to anything. Respectful conduct or appropriate conduct could mean myriad things without something that helps define what it might mean. It's in the confusion. It's in the confusion here, Your Honors, that the employees would hesitate in doing something. And that's what this court cares about.
But the NLRB said that it wasn't overly broad in Costco, correct?
It wasn't overly broad because it was appropriate business decorum, appropriate followed by specific types of conduct. And moreover, in Costco, a rule that prevented any conduct that damaged the employee, damaged the company, or damaged that person's reputation was found to be unlawful.
This is a workplace rule.
It certainly was a workplace rule, but we have the similar language in this policy, which therefore is similarly
Isn't this a
overbroad.
narrower language than Costco, actually?
I would think so.
This is tighter, it seems to me, using words like humiliating, intimidating, threatening, obscene, malicious. That seems to me to be actually a tighter standard than sort of a civil workplace or that kind of thing. I mean, you could argue that this is narrower than Costco rather than broader.
Indicia of disrespect.
Yeah.
Perhaps, Your Honor, but the fact remains that that particular provision must be read in context with the entire document, and this Court should adopt the Fourth Circuit's reasoning that the mere presence of some overbroad language creates an overbroad policy on its face and is thus unlawful.
Isn't there a bigger problem that the Hispanics of Buffalo case requires that to be protected activity, the objective of a post on social networking must be for mutual aid? What was the mutual aid that was sought in this post? It seems to be venting, really.
As to the particular enforcement, Your Honor, that you're referring to, in Hispanics United, the Court made clear that that objective need not be explicitly stated within the statement, but may be implicit from the surrounding circumstances. And the surrounding circumstances of the schmoozer posting are critical to understanding what Mr. Henson, Mr. Clash, and Mr. Jacobson were doing. They got to the bar Friday night after a long day of work and decided to discuss the fact that they're not being paid for the time that they are spending donning and doffing their clothes. Mr. Jacobson said, "This is like working for free." Moments later, they all decided to post this online. Indeed, vent this online together. Mr. Henson posts online, "I work for some incompetent morons. I'm not valued. I'm going to do something about it on Monday." He is initiating, he is inducing, and he is preparing for group action on behalf of Mr. Jacobson and Mr. Clash.
Who decides what it is that the reasonable employee would think about this? Who decides that?
The Court would look at that.
Factual question?
It would be a legal question, Your Honor, as to the meaning of reasonableness.
Should the Court of Appeals have deferred to the district court on that finding?
Certainly, and the district court found that context in this case was the key to finding reasonableness. Indeed, the National Labor Relations Board itself indicates that the context of such statements is the key to deciding what's really happening in a post such as this on social media.
Well, isn't part of the context that these guys had worked double shifts, they were at a bar, and were tired and angry? I mean, isn't that part of the context?
Absolutely. Absolutely it is. They're working.
Where does that cut?
That cuts for the fact that they are engaging in activity that the National Labor Relations Act is designed to protect. Mr. Henson and the other two employees are protesting supervisory actions, as the First Circuit held in Five-Star Transportation. They all believe that their managers of their company are not doing their jobs properly because they're not getting paid for the time that they're working. So not only are they inducing for group action, creating concerted activity, they're engaging in the type of conduct that has direct relevance to working conditions, hours, wages.
Shouldn't they have gone to their union?
They could have, Your Honor.
Doesn't the union have the exclusive right to bargain on behalf of these employees?
It's not clear in the record whether that right is exclusive.
Doesn't the law provide for that?
It's unclear from Wagner state law whether that is a provision. In this case, the three employees wanted to do it on their own. And that is exactly the type of initiative that we want to protect on behalf of employees, to allow them to get together, discuss the fact that there are tensions in this workplace. Something's going on that's not in satisfaction of our working conditions. So let's do something about it.
Well, if they have a union, don't we want to encourage them to go through their union?
Certainly, Your Honor.
So is there any element of the fact that they did not go through their union which would render their conduct unprotected?
Not at all, Your Honor. It's certainly clear that the union did not negotiate this matter. And as times evolve and social media comes into play more and more often for these employees, they are concerned that their actions are going to be infringed upon. And that's where we find these unfair labor practices on behalf of Grover. Mr. Henson and Mr. Jacobson and Mr. Clash, I see that I'm out of time, Your Honor. Thank you.
Okay, any rebuttal? You may proceed.
May it please the court. My name is Grace Popham, and along with my co-counsel, Dave Pulcinelli, we represent the respondent in this case, Grover Waste Solutions Incorporated. During my co-counsel's time before the court, he will explain how Grover's social media policy complies with the National Labor Relations Act. And during my time before the court, I will explain how Grover's policy of non-compensation complies with the Fair Labor Standards Act for two reasons. First, Section 2030 of the FLSA applies in this case. Second, even if this court finds that Section 2030 does not apply, the employer is still not required to compensate the employees for these activities because they are not principal activities and they are de minimis.
Isn't the most important question here, even under the Sandifer case, whether the 30 minutes that are spent daily in this activity, and that's uncontested, that it takes 30 minutes daily, 2.5 hours over our average work week, that's more than de minimis, isn't it?
No, Your Honor, it is not more than de minimis.
It's certainly different from what Judge Posner described in the Sandifer case. And as we've heard from your opposing counsel, it amounts to more than $2,000 a year.
Yes, Your Honor, you are correct. It does amount to $2,600 a year. And as you were referencing the Seventh Circuit case in Judge Posner's opinion in Sandifer versus United States Steel Corporation, he made the point that de minimis may be something, but not something more than mere an absurdity of split-second decisions or activities like putting on your goggles for a split second. But in this situation, we must apply the Ninth Circuit's test, a three-factor test under Lindau versus the United States from 1984. Now, the three factors are the difficulty the employer would have in documenting the additional time, the aggregate amount of additional time, and the regularity of the additional time. Now, in this case,
It seems to me that it meets all three factors. They're doing the time after they've clocked in, so it's being measured, right?
actually, in this case, they put on and take off the equipment once they put on the equipment before they have clocked in for the day, and they take the equipment once they have clocked out for the day.
Oh, I thought it was, sorry.
Isn't this integral and indispensable, though?
No.
Indispensable?
No, Your Honor, it is not integral and indispensable. And after we analyze whether or not it's integral and indispensable, then is the proper time to determine whether...
It's not integral. Could they do the work if they didn't change the clothes? Would they be permitted to go out and do the work? Could they do the work without changing the clothes?
Yes, Your Honor, they could do their work without...
It would violate the law.
Yeah, I thought
and would
people-
expose the company to significant costs in workmen's compensation claims and other types of health claims. How could it not be integral?
It is not integral as established by the integral and indispensable test that this court established in Steiner versus Mitchell. Now, in Steiner versus Mitchell, battery plant employees were required to put on and take off protective equipment based on the dangerous nature of their job. Now, they were exposed to lead every single day, lead poisoning. Not only could they hurt themselves, but also hurt their families if they brought that protective...
These employees are exposed to toxic waste and medical waste every day, aren't they?
Your Honor, they are exposed to chlorine, ammonia, and lime, as indicated by page 5 of the record. And there is some waste that can come from facilities that they are treating. But their primary duty is to treat the waste as well as the equipment and maintain the equipment that it takes.
It exposes them to the waste doing those tasks, doesn't
Yes,
it?
Your Honor, it does.
And they're dealing with toxic substances.
Yes, Your Honor, but in terms of applying the integral and indispensable test, this court in Steiner established that an activity must be both integral and indispensable. Now, the Second Circuit in Gorman versus Consolidated Edison Corporation explained what exactly integral and indispensable means.
If
Now,
it's illegal not to put on this clothing, this protective clothing, it's illegal. Isn't it become indispensable and integral that just to obey the law, you have to put this on before you can legally do the work?
actually, Your Honor, it's not illegal. It would be illegal, according to page 5 of the record, for Wagner or for Grover not to provide the equipment to the employees. The state law mandates that Grover supplies and provides this protective equipment.
Counsel, the petitioners told us that not only that, but that it's got to be stored at the facility, and there has to be you have to provide a room within which to change and shower and so forth. Is that all true?
The Wagner state law mandates that the employer provide protective equipment in order to protect against hazards. Now, in this case, according to page 5 of the record, currently the equipment is being stored on the locker room. But as far as being mandated by state law that it be on the facility is...
So an employee could come to work, report to work, never change out of their street clothes, whatever those are, and leave, work his entire shift, leave, never change, and there'd be no problem.
No, Your Honor, you are correct. It is mandated by company policy that the employees don and doff this equipment, but that is not one of the factors that goes to compensability or whether or not it's a principal activity.
Isn't it the public policy of the state of Wagner that employees doing this kind of work wear protective equipment? Let's start with that.
The record is unclear as to exactly what the state of Wagner's public policy is, but there is the state law that mandates that Grover supplies this protective equipment.
You don't think that's an indication of what Wagner's public policy is?
Yes, Your Honor, it could be, but it still is not a factor, according to the integral and indispensable test that this court established.
How can you separate the company policy when you look at the state law?
We can
just yield the conclusion that it's integral and indispensable?
No, Your Honor, and we can distinguish the two because according to the Second Circuit in Gorman versus Consolidated Edison, being required by the employer is not a dispositive factor in deciding whether or not an activity is principal. Now, in order to explain a little bit further about what integral really means, the Second Circuit defined it as essential to make whole or complete. It gave several examples. For example, sharpening a knife before you're able to carve a carcass, as this court established in Mitchell versus Packing Company. Additionally, as established by the Second Circuit in Kosakow versus New Rochelle Radiology. An example is turning on, powering up, and testing an X-ray machine before you are able to run an X-ray on a patient. That is integral, and that is indispensable. Now, before we even get...
An employee who every day went to work, never opened his locker, just walked in, did his work for a day, every day. Then at the end of the day, just went home, never showered, never changed, day after day after day. Do you think the Grover would get into any difficulty over that if it knew it was happening, if it was aware, if the supervisors were aware that this employee was just going in every day, working around the waist, exposing himself to toxic, and just ignored the equipment, which was sitting there, but he just never used it? You think that would be okay?
I'm sure it would not be okay, Your Honor. The record is unclear, however, as far as as what Grover would do. What we do know from the record is that it is mandated by state law that Grover supply this equipment. But before we even get to the principal activity part of the argument, we must first determine whether or not Section 2030 applies in this case. Now, Section 2030 specifically states that an employer may, when calculating compensable time, may exclude from compensable time the time spent changing clothes, as long as that clothes changing time is also excluded by either the express terms of a collective bargaining agreement or of a custom or practice under a bona fide collective bargaining agreement. Now, in Sandifer versus United States Steel Corporation, the Seventh Circuit addressed the meaning under the statute of the word clothes. In defining clothes...
A different result in the Sixth Circuit.
And I believe you're referring to Franklin versus Kellogg?
Yes.
Yes, Your Honor. Yes, Your Honor, you're correct. And in what the Seventh Circuit got right about the interpretation of the word clothes is looking at the congressional intent behind the FLSA. that, to quote Judge Posner, it would be beyond odd to believe that Congress intended to exclude work clothes from the definition of clothes, considering the fact that the FLSA was enacted for the workplace, for clothes that employees are required to put on and take off at the beginning and end of the workday.
Well, isn't this remedial legislation, though? Aren't we supposed to construe it narrowly and say clothes can be work clothes, but when you get into protective equipment and protective clothes that are required either be worn or supplied by the state law, that we should narrow our interpretation of that?
No, Your Honor, we should not narrow the interpretation of the word clothes. We should specifically look to the congressional intent and context of the FLSA as cited by Judge Posner in Sandifer versus United States Steel Corporation. Now, Judge Posner directly responded to the Ninth Circuit's definition of clothes in Alvarez versus IBP. And that definition was clothes are items worn for decency or comfort, not for protection from hazards. But Judge Posner cited and noted that all clothing has some sort of protective quality about it, whether or not it's from bug bites, from a sunburn, or from cold weather. But just because something protects you doesn't mean it's not clothes. Now, the Fourth Circuit, yes, Your Honor.
Counsel, but Judge Posner rejects in this case, or in the Sandifer case, the interpretation of the Department of Labor, the expert agency. And in contrast, in Franklin, the court accepts that interpretation. And I'm more persuaded by the ruling of the Sixth Circuit in Franklin concerning the Department of Labor's interpretation.
In Franklin versus Kellogg, the Sixth Circuit noted the Skidmore versus Swift factors. Yes. And while the court in Franklin ultimately decided in the same way that the most recent Department of Labor opinion letter had held, they applied the Skidmore factors and found that this court must be careful in the deference that this court gives to the opinion letters. Now, specifically,
what deference should we give to the last opinion letter? Because they were changed 3 times. What deference should we give to that last opinion letter?
In order to determine the amount of deference we should give to these opinion letters, we must apply the 3 factors from Skidmore versus Swift. That is the validity of the reasoning, the thoroughness of the consideration, and the consistency with prior pronouncements. Now, the fact that these opinion letters have changed 5 times since 1997 shows that the deference should be less deference in this case.
Although the latest interpretation is, in fact, the one that has prevailed twice.
Yes, Your Honor.
In recent years. And, in fact, the departure actually is the one in the 2002 and 2007 period, isn't it?
Yes, Your Honor, you're correct. They are consistent in 1997, 2001, and 2010. However, and this court, of course, can find them persuasive, but they are not binding. Now, furthermore, if this court decides that even the protective equipment is not closed, there also has not been a customer practice established of non-compensation. Now, the 11th, 3rd, and 5th circuits have addressed the standard of knowing acquiescence. Now, specifically in the 11th circuit, Anderson versus Kegels took place in a poultry processing plant, and in that
provision in the collective bargaining agreement that says that everything has to be in writing and signed by both parties.
That is correct, Your Honor. The CBA cites that anything regarding wages or compensation must be expressly in the CBA and prohibits customs or practices.
Not cut against you? I mean, if you're arguing that non-payment is the custom and practice, and there's no writing anywhere that says that, doesn't that strongly cut against your position?
It does not strongly cut against the respondent's position, especially when we look to the knowing acquiescence standard, which has been used by the 11th, 3rd, and 5th circuits in order to determine whether there is a legally binding customer practice. Now, in Anderson versus Kegels, the case was very similar to this one. There were no express terms in the CBA, and there was no evidence of negotiations.
Isn't that provision in the CBA designed to avoid this very kind of argument, that there's been acquiescence and what the custom is, an argument over what the custom is? Isn't that what that provision in the CBA is designed to eliminate? That it's got to be in writing, it's got to be signed by both sides, so we don't get into arguments as to what's acquiescence, what's not acquiescence.
That would certainly make the situation much easier if it had been negotiated in the CBA. But in this case, the record is silent. The CBA is silent about the express terms, which shows, according to the 11th Circuit, that absence of negotiations means acquiescence. Now, this is important because the employer has the right to have a mutually trustworthy relationship with their employees, to have given multiple opportunities every 3 years, according to page 3 of the record, to negotiate this out. But instead, the employees have sat idly by and then want to sue for 20 years of back pay, when according to the record on page 3, they have had the
sue for 20 years of back pay. Isn't there something called a statute of limitations in the FLSA of 3 years? Nobody's going to get 20 years of back pay.
I see that my time has expired. Thank you, Your Honor. Okay. There may be a statute of limitations, but according to page 4 of the record, Grover has been active since 1993, and that is one of the damages that the petitioners are seeking. It is for these reasons that we respectfully ask this court to affirm the opinion of the court below.
Thank you very much. Mr. Polsinelli?
May it please the court. My name is Dave Polsinelli, and I also represent the respondent in this case, Grover Waste Solutions. And in my time before the court, I will explain why Grover did not violate the National Labor Relations Act for 2 reasons. First, Grover's social media policy is not facially overbroad. And second, the petitioners were not terminated for engaging in a Section 7 activity. As pages 6 and 7 of the record reflect, on October 26, 2012, Mr. Henson decided that he was going to publicly insult his employer, Grover Waste Solutions, and his supervisor, Oscar Bird. His way of doing this was, after having a few drinks at the bar, he used his personal cell phone to create a group on Schmoozer, a popular social networking site. That group was entitled, Who's Got a Loser Boss? After creating this group, he invited 18 people who had no connection whatsoever to Grover. And after sending out these invitations and creating this group, he posted a message to the group. And that message stated, I work for some incompetent morons. As page 6 of the record indicates, he did this with the full knowledge of Grover's social media policy.
But since most of the people he involved in this post are outside of the company, doesn't that in fact make the case that this had no disruptive impact and wasn't intended to have any disruptive impact on Grover?
No, Your Honor, not necessarily, because we're dealing with the internet in this situation. And according to Business Week, over nearly 1.5 billion people use social media. So there's nothing in the record to show that this group was private in any way. And further, the only way it's going to remain protected is if it's concerted, and it's for the mutual aid or protection of other employees. And we don't even establish that in this case.
Counsel, there are different kinds of workplaces. There could be a back office of an insurance company, a very genteel workplace. Then you have rough and tumble workplaces. Doesn't a waste treatment plant fall into the category of a fairly rough and tumble kind of employment environment? And maybe a little rougher language would be the norm there, as opposed to, they say, the back office of an insurance company where they're filing papers, where maybe certain kind of language that would be routine on the floor of a waste treatment plant would be pretty unacceptable. Does that play a role in your thinking here? It's a pretty rough and tumble kind of workplace, isn't it?
Your Honor, yes, the record does establish this is somewhat of a rough and tumble workplace. But that would maybe have some effect if the discussion was taking place at work, in the middle of a heated discussion, when he's having like a discussion that's in the midst where emotions are invoked. But he's having this discussion after having a few beers at the bar.
What does the few beers at the bar have to do with it? I mean, what does that have to do with the case?
The fact that he's not using his best judgment. And by his own admission, as page...
Do you have that he was drunk? I mean, is that in the record?
No, Your Honor, that's not in the record that he was drunk. It's just to illustrate the point that this isn't taking place in the middle of a heated debate about a labor dispute.
But you please go ahead.
doesn't that work the other way too? If the location is outside the workplace, it's not disruptive of the workplace, it's in a social situation.
And he used his own cell phone to post it?
To answer Your Honor's questions, it would work against the respondent if this was a private message, a private text message, a private email. But because he posted this message on a social media website that's available everywhere, it doesn't it doesn't change the fact that this potential message is available at the workplace.
Wait. What about a picket line where people are walking up and down with signs that say their employer is unfair, their employer
And a giant
stinks?
rat.
Or what about a banner? The Labor Board has said you can have these big banners that say it's unfair. You can take a full-page ad in the New York Times that says your employer is unfair, it is a rat. What is it about it being on social media that suddenly you can't do this?
Your Honor, certainly a picket line is the prototypical Section 7 activity. But stating something on the Internet that has no sufficient nexus to a labor dispute is not a Section 7 activity. As page 7 of the record indicates, he's speaking in the first person singular. He's stating, I work for some incompetent morons. They don't value me.
Actually, though, when I'm reading from your letter to Mr. Henson, and you say that you terminated his employment for publicly, and this is a quote, publicly disparaging and embarrassing the company and Mr. Byrd. I can't imagine anything more publicly disparaging and embarrassing than the giant rat in front of the building. So clearly, it's not whether your sensibilities are offended that determines whether or not it's protected activity, correct?
Yes, Your Honor, that's correct. But there still must be a sufficient nexus to a labor dispute. If someone's holding a big sign in front of the office building or in front of the treatment facility that's showing that they're engaging in a type of strike, a type of picketing, that has that sufficient nexus on its face that it's relating to a labor dispute.
Well, but he was complaining about his work. 2 fellow employees said they liked it. Isn't that sufficient to bring? And he was complaining about, while he may have used the word I, he was complaining about a policy that applied to everyone. So isn't that enough to make it? He was complaining about a condition at work that applied to everybody, and he got a couple of people to actually say they agreed with, or liked what he was saying. Isn't that enough to get over the barrier of concerted and protected?
It's not enough, Your Honor, because on the face of this statement, we don't know that he's referencing this policy. All he states is that he doesn't feel value. The word value is so over...
Didn't he say, I feel like I'm working for nothing? Which is the very issue that we're talking about. I mean, isn't that a pretty square statement as to what was bothering him? I'm working for nothing, he says. I've worked day in and day out for nothing.
Yes, Your Honor, but he made that statement at the bar, not online, which is the issue before this court. His statement...
Entitled to look at the whole context here?
Not necessarily, Your Honor, because they were terminated for their statement on the Internet. And so we're looking at it from the perspective of an objective person who's looking at this statement.
But for the purpose of determining whether it was concerted, don't we have to look at what it grew out of, which was a conversation among 3 employees? And don't we have to look at what it led to, which was the meeting among these employees and Mr. Byrd? So isn't a court, do we have to put blinders on and say this wasn't concerted because this particular event in this ongoing from one day to the next set of actions, series of actions, this particular event has to be judged just by itself?
No, Your Honor, not just by itself. But we want to look at what happened before. That yes, all 3 men had a discussion. But as NLRB versus Mushroom Transportation Company pointed out, the seminal case on this type of concerted activity, just because employees are having discussions about matters of common opinion, if they don't state explicitly or from clear inference that they intend to take a future action that is protected, then it's not anything more than a mere gripe. In that, as page 7 of the record indicates, they only said that they intended to vent online.
Well, let me ask you this. Let's assume they had done everything they did that night, except call him a moron or except say anything personal. They just posted online, we feel like we're working for nothing, this is unfair, but they didn't say anything personal about the supervisor. They omitted anything about him being a moron or being a bad boss. They just protested the policy online. Could you have fired him for that?
Probably not, Your Honor.
Why not?
Because if they did state, I work for free, that my boss isn't giving me the proper compensation, and there was a sufficient indication on the face of the statement that it was dealing with a labor dispute, then that would be protected activity. But we don't have that in this case.
A labor dispute that night? I mean, you can see that what happened at the bar could create a labor dispute.
No, Your Honor. The fact that they had this discussion, there was no future indicated action at the bar. The only time it became a future indicated action was the following day, after the statement. So if we excuse this, then potentially we're excusing all types of disloyal and insubordinate activity just so long as they go and make a legitimate complaint.
But aren't we entitled to infer that from the time that the posting happened until the time of the meeting with the supervisor, that in fact this was part of a series of actions that were protected activity?
No, Your Honor, we can't make that inference without looking at the facts, because the facts show that before he ever made this statement, the only thing they talked about was venting online.
Well, actually, all Mr. Clash did was receive this, isn't that right? And how did you apply this policy to justify, or how do you justify terminating him when he received the statement? He said nothing, except, what about the football game?
Your Honor, Grover had the right to terminate all 3 employees because they were not engaged in a concerted activity. And one of the great things about America is that we have freedom to make business decisions. This isn't a situation where they're
freedom to speak.
Yes, freedom to speak. If you're dealing with a situation where the government interferes, that might be a problem. They certainly had a First Amendment right. They didn't have a Section 7 right to make these statements. They're not immune from Grover's right to terminate them. As this court decided in Republic Aviation Corporation.
What did Mr. Clash do again that justified his termination? Precisely, what did he do that justified terminating him?
He liked Mr. Henson's statement, and he also had a...
He liked?
Yes, Your Honor. There's as page 7 of the record...
Befriended, you mean?
Yeah.
Befriended?
No, Your Honor. As page 7 of the record indicates, the like button on Schmoozer, which is very similar to the like button on Facebook, allows a person to show that they enjoy the statement that a particular person has made.
So what he did to get fired was enjoy a statement that another employee made?
Yes, Your Honor. And because Grover has this particular freedom, as this court pointed out in Republic Aviation Corporation, to make business decisions that are able to enforce maintaining discipline in the workplace, it doesn't matter that his level of activity didn't rise to the same egregiousness as Mr. Henson.
But both lower courts here found that ultimately they were fired in retaliation, isn't that right?
Yes, Your Honor.
And your freedom to discipline your employees does not reach your ability, the ability to terminate them for exercising protected rights, correct?
Yes, Your Honor. But where the lower courts erred is the fact that they were focusing on that when they came into the office, which was a protected activity. But the issue before this court is the online statement. Because the online statement is not a concerted activity, Grover has the freedom to terminate them.
Let me ask you this. I asked the petitioners this question. These folks were represented by a union, and the union has the exclusive right to deal with the employer on their behalf. Should we consider whether this is protected or not protected because they didn't go through their union?
We can certainly give that some consideration, Your Honor, yes. And they explicitly stated, as can be seen in the bottom of page 7, that they contemplated bringing it to their union steward, but then decided they were going to do it on their own. But this policy itself is not facially overbroad, because this is not the only company. Grover's not the only company in America that has a policy like this. In fact, Walmart has a policy that's virtually identical. And the Office of the General Counsel of the NLRB has stated that policy is not overbroad, because it does give sufficient examples of what the activity is prohibited that is not intertwined with Section 7 activity. Similarly, in Palms Hotel and Casino from 2005, which prohibited injurious, offensive, threatening, or intimidating conduct. The NLRB stated that policy was okay because none of that activity that's prohibited is intertwined with Section 7 activity. So an employee is not going to reasonably construe it as being prohibitive of Section 7 activity. And as the NLRB stated in Lutheran Heritage Village, following this court's reasoning from Broderick versus Oklahoma, overbreadth should be a policy that's applied very sparingly, because necessarily employer rules are going to be general in nature. And it's unreasonable to force an employer to think of every conceivable time that the prohibited conduct is going to interfere with a right. And also, we don't analyze this rule from the perspective of a labor law expert who could think of some conceivable way that the prohibited conduct would overlap with Section 7 activity.
But we're not talking about here whether somebody looked at the rule and reasonably thought, gee, this might mean I can't engage in protected activity. I better not do it. We're talking about the application of a rule to fire somebody. So what difference is it what it makes to mean to a reasonable employee? They fired this employee over what they felt was a violation of this rule.
Yes, Your Honor, but petitioners are bringing a claim based on the face of the rule as well as how it was enforced. But in the face of the rule is not overbroad, pursuant to the NLRB's rulings in Lutheran Heritage Village and Palms Hotel and Casino. But as far as the concerted activity is concerned, this case is very similar to a case that was decided in 2011, a Walmart case, where one employee, after meeting with his assistant manager, posted on Facebook. And he stated, "Wuck Walmart. I swear if this tyranny does not stop, Walmart's about to get a wake-up call because lots are about to quit." And the general counsel for the NLRB stated that that was nothing more than a personal gripe and a plea for emotional support, despite the fact that other employees liked his statement. Because liking doesn't rise to the sufficient level of indicating a future activity, a future action. And because of that, because the statement is nothing more than a mere personal gripe, the activity is not protected. It is for these reasons the respondent respectfully requests that this court affirm the judgment of the Court of Appeals in all relevant respects.
Thank you very much.
Just 2 brief points on rebuttal, Your Honor. Respondents today admit that the local working conditions provision in the contract prevents any unwritten custom or practice. Because this prevents unwritten customs or practices, then any implied term of contract to the contrary would not trump this explicitly agreed to provision in a collective bargaining agreement.
It's possible for us to think that, well, for purposes of contract, we're not going to have any sort of unwritten, understood provisions of the contract. But for other purposes, for example, reality, I mean, the reality is, whatever they may have agreed to under this contract, is that there has been a long-term custom and practice of not paying. Can't we just limit that provision in the contract to contractual claims, not legal claims?
No, Your Honor. Here, the local working condition provision states that nothing regarding wages or hours worked can be implied in the terms of the collective bargaining agreement without a specific written provision to the contrary. Therefore, it would prevent customs or practices in this area. As to my second point, Your Honors, the respondents correctly state that under the National Labor Relations Policy, you have to balance the right of employees to engage in collected activity against the right of employers to maintain order in the workplace. Here, the Post says, "I work for some incompetent morons. They're about to get a piece of my mind on Monday." Complaining about his boss, calling him an incompetent moron, is a complaint about his working conditions. And he is building momentum for future action, future collected action on Monday. Now, in balancing this against the right to maintain order, this Post does not mention Grover, and it does not mention Mr. Bird. Therefore, it is protected, and this was an unlawful termination. Thank you, Your Honors.
Okay, I think we're going to adjourn to deliberate our verdict, our decision, and I would like to thank all 4 counsel. They did a wonderful job, and it was a pleasure listening to them, and we will return, I don't know, shortly, but fairly quickly.
All rise.
Thank you, everyone, for a great round. If you could just wait around, they should be done shortly, and then we'll announce the winners. Both teams did a great job. Congratulations.
Final year, yes. Excited to be done. Thanks we're done with these, right? I can go bring this back? Okay, great.
What's it?
Oh, it's like awesome. No, it's like awesome. Good job, guys. Good job. Talk pushing. They're the ghosts. That's what they do. I mean, I'm just I've never been quite around. I didn't know. They just take this long. Honestly, like, yeah. Like, this is maybe after the never
Isn't so nice.
yeah, consider next. They're all in New York City. All in New York City. She has. Right, that's right. I don't know. I just remember the question.
Great job.
Someone just texted that they're I'm sorry. Oh, no, I Oh, you did? Okay.
Excuse me, if everyone could please take your seat. We're ready to make announcements.
All rise.
Everyone, please be seated. In the man of La Mancha, you have the knight of the woeful countenance. I am the justice with the robe of woeful countenance. That neither zippers nor hangs straight. It's a son of insult for a chief justice. Well, the one thing I can tell you all is that all 5 justices were mightily impressed with the quality of the arguments we heard before us. I've been listening to oral arguments for 20 years, and I probably listened to, even though I'm a district court judge for 3 or 4 years, I sat regularly on the circuit, Third Circuit, and I heard, well over 100 oral arguments in that period. And the arguments today compared very favorably with some of the best that I heard when I was sitting on the Third Circuit Court of Appeals. And everyone here, the 4 of you are to be congratulated in what for us was a very, very difficult decision. However, I guess we're in the decision-making business, so we have to make decisions no matter how difficult they are. And again, I want to emphasize, we have to choose a winning oralist, we have to choose the winning team, but you all really did yourselves proud and your schools proud. You did very, very well, and we appreciate that. It makes what we do here very enjoyable. That's why they keep coming back year after year, because it's so enjoyable. We found that by a small margin, the best oralist was Catherine Fraser. again, by a narrow margin, we found the petitioners to be the best candidate. Now, I think it's customary for me to let each of the justices say a few words about what they saw today, and I'm going to start with Ms. Berrien. There you are.
Well, I certainly echo the universal compliment. It really was extraordinarily high-quality argument. I spent a significant amount of my career working on federal appellate cases, and particularly many matters that went to the U.S. Supreme Court, and have seen many, many U.S. Supreme Court arguments. And I would say, again, that the caliber of argument here was extremely high and rivaled some of what I have seen in the Supreme Court. So I commend you thoroughly for your preparation, for your delivery, for your presentation. A couple of specific points I just wanted to highlight. First of all, to start with Mr. Polsinelli. In many ways, I think you had what might have been the most difficult argument. And I think certainly one of the things that was very striking to me was how you managed to walk what is a very, very difficult line between zealous advocacy and yet being sensitive in ways that I think helped your client and your argument to what might be too far and where it may be difficult to take the court. And I think you read the court in terms of how to walk that line very accurately. So I do hope that for both teams, please know that the statement that things were extremely close is true, that you have presented arguments which in various ways were difficult and demanding extremely well. And I wanted to particularly commend you on that, which I think is not something that one easily learns or acquires. It may be that at least it starts as a gift, and I think you have it, so congratulations to you. Ms. Popham, again, I think that one of the greatest challenges that one can face as an appellate advocate is sensing that there is a bench that is resisting where you're trying to take them and determining what to do about that. I think you faced perhaps the most challenging set of circumstances where there was some back and forth with the bench about an aspect of your argument. I think that you were poised and worked very hard to bring us to your point of view. I think ultimately it is one of the most challenging things that you can face as an advocate, and I commend you for the way that you handled that. I think that, though, one of the ultimate challenges also in appellate advocacy is how much time you actually get to reserve for your argument, and at some point where the balance is between the bench overtaking your time and being able to make the points that you did. That said, I thought actually that the balance of your time you used very effectively, and you did expose us to a range of your views. Mr. Webster, in some ways I think you did an extraordinary job in getting us out of the law, getting us out of the parsing the language of the statute and trying to bring us to the point of understanding that this particular thing, which is clearly not what Congress had in mind when the statute was written, there was no social media, there was no schmoozer, there was no liking. I felt, though, that you contemporized the statute and made us appreciate that the statute was intended to be applied in the way that you were arguing it should be, and that though Congress had not expressly written the words for this purpose, I was persuaded by your argument that, in fact, we ought to believe that they were written for this purpose, which is not an easy thing to do. And finally, Ms. Fraser, I think there were many things. I think you had a lot of terrain to cover. I think if there was you were extraordinarily challenged in how to cover it with an active bench and with so much ground to cover. But I thought one of the most effective things that you did was how you used the 2 minutes of rebuttal time, which I have seen range from ineffective and a waste of time in actual arguments to disastrous. And it's always a risk, actually, when you stand up and do rebuttal. And what you decide to use those 2 minutes for can make or break your case. And frankly, I think that, for me, was the thing that both made your argument and ultimately was the decisive point in terms of your skill that was recognized in the Best Oralist Award. It is a very difficult thing to figure out what you're going to do in those 2 minutes usefully. And then my partner on the bench jumped right on you, and you still got in the second point, which to me was the best last word you could possibly have done. So I congratulate you all, but I think in various ways you did some things that really made you stand out. Thank you.
Dean?
Thank you. I, too, have enormous admiration for the performances here today. I was extremely proud of all of you. Just tremendous, tremendous skill was shown, command of the facts, the law, an ability to connect with the judges, an ability to answer questions and to navigate through a lot of tough terrain in terms of what was coming at you from a variety of places on this bench. So all of you should be very commended. I, too, have seen many Supreme Court arguments, and again, great skill here, and certainly you are all contenders. You will all go to great places. Let me start over with Ms. Popham. I thought that you had a terrific presence. You had, there was some good connection with the judges when you were responding to questions. I did think that while you had a command of the information, it's an issue of time management sometimes, and you all know that, but sometimes you have to sort of map it out in your head where you want to go and work with the questions you're being given to get you there. And obviously always being responsive and full, but at the same time trying to pivot when you can. But still, an extremely admirable performance. Mr. Polsinelli, you had a very difficult job, and I actually could relate to your situation. I have found myself in your situation a few times.
The last trustees meeting, I'll bet.
But I thought Judge Berrien said it well about how you knew where the line was, but you didn't cross it. And it was certainly tough. You had a tough client and a tough set of facts and law to deal with, but really well done. And I thought it was very deft. You navigated it very deftly, so congratulations on that. And you made a very nice team. Mr. Webster, I thought you had great command of the law and the facts, terrific thoroughness in answering questions. Sometimes I sensed a tad bit of defensive-ness, which happens. I don't think it diminished your argument. You have to be mindful of that. But really strong, great presence, a lot of confidence, but not in a way that was appealing. It was, I wanted to hear your story. I wanted to get to where you were going. So that was helpful. You educated the bench. That was great. And Ms. Fraser, you had a very difficult job to be the first and the last person to speak. And you were able to command an enormous amount of information in a very difficult and complicated case extraordinarily well. And, a beautiful presentation. There was an elegance to the way you presented. I really admired that. And you had challenging issues. For me, watching the entire argument, there were certain aspects missing. And your rebuttal came back, and it was terrific. It really was well spent in terms of listening very carefully to what was going on, in the argument and coming back and responding in a way that was appropriate, forceful, and ultimately very persuasive.
Thank you very much, Dean. Mr. Meisberg?
I once answered a question in oral argument. The question was, Mr. Meisberg, why is that your answer? And I responded, because if that's not right, my client loses. I was very young. None of you did that. That's good. I spent the better part of the first half of my career as an appellate advocate and arguing in the courts of appeals, and I appreciate the difficulties that presents. In the years I've been doing, this is my 5th year to be on this bench, this was the closest I can remember in terms of the teams and the best advocates awarded. It was a very, very well-presented argument from both sides. You all had some chinks in your armor. And I think the thing that is important, and you all did this to a degree, some of you did it better than others, but if you've ever ridden a horse down a path, and horses have this desire to kind of pull off to one side, they want to nibble on the branches, and you've got to exercise a terrific amount of effort to keep pulling that horse back on the path. Each of you, when you start your argument, you've got a path. You want to take this court down, and the court's the horse. And the court, you'll get questions from left field, right field, center field, and it is a key part of oral argument, not just to be able to be articulate and know the law and know the record. And all of you, by the way, were articulate, and you knew the law and you knew the record. That was very impressive. But that ability to pull the court back to the point you need to make to win your argument. And that's not always easy. And sometimes it's well nigh impossible. But I saw you all struggling to do it. As I say, I think some of you did it with better degrees of success than the others. And I want to congratulate you on an argument well presented.
Okay, thank you very much. And finally, Ms. Stevenson.
Thank you. I agree with everything that's been said so far. I thought it was a very impressive argument. I thought you were all amazingly poised in the face of sometimes a lot of repetitive, a lot of questions, so that it was a little difficult for you to get your argument out. But it was very well done. Again, Ms. Popham, you were very well poised, and you handled yourself just very, very well. And Mr. Polsinelli, I like the way you would turn a question into what you needed to say to the court, what you needed, and deflect the question into your strongest part of your argument, which is, I think, what he was just saying. So very well done. And again, it was a very, very close call, and I enjoyed hearing your arguments. Mr. Webster, I thought you did a very good job. I thought you were very responsive to the questions, and again, very smoothly answered the questions and moved on with your argument, and I thought that was very well done. And Ms. Fraser, again, the rebuttal was terrific, and that's a really important part of an argument, I think. It's underestimated. So, again, I congratulate you all. You did a wonderful job.
Thank you. I, of course, join in the comments of my 4 fellow justices. I agree that it was a very close competition and that the performances were outstanding. A friend of mine, a district judge in the Middle District of Alabama, gave a speech once. It was at a memorial service for another judge, another famous judge in Alabama who had been a strong defender of Brown v. Board of Education. And he said what he had learned from that judge was that you argue to a judge, you don't argue with a judge. And I thought all 4 of you, to a great degree, had already learned that lesson, and that it would have been very easy to start arguing with us. But I think you all resisted that temptation. You argued to us, And you used the questions, which were in many cases very difficult questions, as an opportunity to elucidate your opinion and not become adversarial. Become adversarial to each other, but not to us. And I thought you, all four of you actually did a pretty good job at that. You learned to argue to a court, not argue with a court. And I found that the best advocates before me are those that avoid at all costs taking an adversarial position with me, or when I'm sitting with three judges on the Court of Appeals with the panel, but rather use a question, however difficult and however confrontational the question may be, as an opportunity to elucidate your position. And I just thought there was a very high degree of maturity in all four of you, all of whom could be my grandchildren, that it was a remarkable degree of maturity, and I commend you for that. If I had to make a criticism, I hate to even use the word criticism because it's not the way I feel about the argument, but you all knew the record extraordinarily well, and you knew the law extraordinarily well. You knew the cases that were relevant, and you knew the facts of the cases, the holdings of the cases. But every now and then I got the feeling that I didn't want to hear what the Sixth Circuit did or what any court had done in a particular case, but I'd rather hear why the particular result, as a matter of reasoning, was a better result. You're focusing on sort of common sense, the facts, and less on that there's a case that went a particular way, when there was always a case that went in a different way. When I listen to arguments, sometimes I say, forget what the law is. You know, why is this result the right result? Explain to me why that result is the right result. And sometimes I got the very slight feeling I'd rather hear a little more of that than the question of, you know, what the District of New Jersey, some judge said, you know, about it. And nobody pays any attention to what the District of New Jersey does. But with that slight comment, you all did a marvelous job. We all had a difficult time reaching a decision, and I commend you. I'll accept the motion to adjourn.